The federal government has disclosed that it was considering three options, which include litigation to address the refusal by the National Assembly to delete Section 84(12) of the Electoral Act 2022 as requested by President Muhammadu Buhari. The Attorney General of the Federation and Minister of Justice Abubakar Malami who made the announcement during a briefing after the Federal Executive Council meeting on Wednesday, revealed that although a definite decision had not been taken on the issue, the federal government would explore all necessary options available concerning the act. President Muhammadu Buhari last month drew the attention of the leadership of the National Assembly to Section 84(12) of the Electoral Act 2022 and requested that the section should be deleted through a process of amendment. The section required political appointees to resign their appointment before participating in primary elections as either delegates or candidates. To talk more on this, Liberous Oshoma, legal practitioner, joins me on the news. Thank you so much for joining us. Now, it seems the federal government is battle ready to have its request granted, but there's a bone of contention that is Clause 84(12) really disenfranchise political appointees who are members of political parties.
I would answer you yes and no. First and foremost, I will say that the federal government is not battle ready. This is not how to be battle ready. That bill was rejected, I think, sometimes last week. And as I speak, apart from a mere opinion expressed by the Attorney General, there is no definite decision by the federal government on what to do, on how they intend to challenge it if they feel, it was improperly thrown away. That said, there have been argument for and against of that section. In one breath, I would say yes, it actually disenfranchises, political appointees. In another breath, I would say no, it doesn't. In as far as party politics is concerned, it disenfranchises, political appointees and does not give a level playing field, to all of the political gladiators. A situation where the governors, for example, deputy governors and lawmakers, president and vice president, can retain their appointment, their seats, while contesting for party politics, while every other person, including ministers appointed and all other persons appointed, are asked to resign, does not create a level playing field. And then if you look at it from another breath, you would say it does not. You can, in one breath, also say that it does not, exclude them from participating. It only says if you want to participate, you would resign your seat. So, but if we're talking about creating a level playing field, then let everybody just resign and then go slug it out in the field. That's what some persons have suggested. But I think, head or tail, first and foremost, we need to actually define, whether political appointment, can be included in the rules. Even though the Court of Appeal has excluded them, the political appointment can be regarded, as public servants or civil servants for the purpose of excluding them from participating in party politics. It is left for the Supreme Court to decide. That's why, for me, I think rather than more this passive opinion on it, the Attorney General should have been at the Supreme Court by now, asking for a determination of that provision, whether it actually interferes with the provisions of the Constitution.
Now, speaking of the Supreme Court now, if the case gets to this, the highest court, what's the chance, or what are the chances that the presidency would have the upper hand?
First and foremost, it is even belated because if most of these people, if they don't resign their appointment now, between now and the 3rd of June or so, there might be, these parties might have issues, they might have problems, because you ought to resign at least before the due date for conduct of primaries. And so at least I think 3 months or so before conduct of primaries. And so by INEC, by virtue of INEC timetable, I think 3rd of June is the deadline within which any of them would need to resign. That said, if the matter gets to Supreme Court, I do not think that it's a matter of the presidency getting the upper hand or the executive getting the upper hand. It's a matter of, argument, superior argument, not necessarily sentiment. It's a matter of laying bare, the provisions of the law in as far as either argument is concerned. And already, in one breath, there is a Court of Appeal decision to support that, the argument of the executive. I think that one happened in the case of Ekiti. Remember when Fayemi was a minister for Mines and Steel or so, that had to resign his appointment to go contest as a governor. But if you ask for my opinion, really, I think we should restrict the persons that should participate in party politics and still hold their appointment. Because what basically is at the crux of the matter here is a situation where for governors to use the offices of political appointment, to oust their opponent during primaries. And that's why you find out governors will appoint 2,000 special advisors, special assistant to special assistant, and all of them become statutory delegates during political primaries. And then once you have such powers to bring in such numbers, there is no way your opponent can actually, compete with you during primaries. And so, but if we limit the numbers of people that can still retain their seats and then vie for primaries or become party delegates, then I think we would have probably balanced the whole issue. But this idea of a blanket, everybody resigning, might actually create problems.
Indeed, Liberace Shama, legal practitioner, thank you very much for your contribution.